Welcome to TVM Press Talk. In Press Talk, we deal with topical issues as they trend in the nation. And today we'll be reviewing the Supreme Court verdict against the IMO judgment. Of course, yesterday the Supreme Court has, in their own supreme judgment, thrown away the review applied by Ihedioha, the former governor that was dethroned. And my name is Daniel Atai, and with me in the studio, two great personalities. By my right is Comrade Silvanus Okwe Esquire, and then at my left is Aisha Salifu. Both of them are ace journalists. Lady and gentlemen,
thank you for having us.
Welcome
Thanks for having us on
to talk show. Now, the judgment of the Supreme Court led by Chief Justice of Nigeria, CJA Tanko Mohammed, held that it lacked powers to sit on appeal in its own judgment delivered on merit and in accordance with dictates of the law and justice. In dismissing the application, the justice with the majority judgment include the CGN, that is Tanko Mohammed. Then we have Olukoyade Ariwola, Sylvester Nguta, Koderat Kekere Ekun, Amina Augi, and Uwani Abba Aji. But in his dissenting judgment, one of the justices, Justice Unweze, held that a judgment or order can be set aside on merit. He said the Apex Court has the power to overrule itself and has done so in the past. Mr. Unweze was not part of the original 7-member panel that nullified Mr. Ihedioha's election on January 14th. He was added to the panel in place of Amiru Sanusi, who retired from the Apex Court in January. In giving his dissenting judgment on Tuesday, Mr. Unweze nullified the declaration of Mr. Uzodimma as governor on account of the wrong declaration. The decision of the Nigeria Supreme Court on the IMO governorship election is wrong and will continue to haunt Nigeria's electoral jurisprudence for a long time to come. One of the judges of the Apex Court said, which is Justice Unweze. We will be discussing that and other issues probably that is making trends in Nigeria. Gentlemen, this is the preamble. Esquire, I will start with you. The Supreme Court has nullified, thrown away the application of appeal from Emeka Ihedioha yesterday. But the paramount issue on the mouths of analysts and Nigerians is that particular dissenting, Justice Unweze, who said the Supreme Court was wrong for nullifying Ihedioha's appeal. What do you think about that?
Well, before I give my opinion on the dissenting judgment by his eminent Justice Unweze Cletus, let me start by commending the justices of the Supreme Court for the bravery and courage in reasserting the independence of the judiciary. It was an attack from the politicians. We know that they have bastardized the electoral process, they have compromised the security outfits during elections, and they have brought this attack on the last and most profound paraphernalia of democracy, the judiciary. What Supreme Court did yesterday was not just a case of looking at the hierarchy of court. They didn't look into the substance of the case. If you ask me of my opinion, I would say the Supreme Court did not look into the substance of the case. They did not look into the merits of the case. They looked at the consequences and the precedents this particular case would create in the future.
Yes, I think so too.
While I will reinstate my respect for Justice Cletus Unweze for that erudite judgment, dissenting judgment, I will also say that the Supreme Court saw beyond the law and the technicalities of the court in reaching that judgment.
Okay.
Had it been judgment was entered in favor of Ihedioha, imagine what would have become of the finality of the Supreme Court.
Exactly.
It would have opened a floodgate of litigation. Litigants coming back to seek for review of their judgments.
Yeah.
And this will be a great abuse of the electoral process. But then, I agree with Justice Cletus Nweze that the Supreme Court, for the records, have powers, competence, and jurisdiction to sit over its earlier judgments when it is ascertained that such judgments were reached per inquiry. We are reached in error.
Okay, that when, is per inquiry.
Per inquiry.
Okay.
Or just as he said, just as he posited in his dissenting judgment.
Yes.
If the judgment did not meet the justice of the case, because they don't just do justice. Judgment should not just do justice must be seen to have been manifestly served by a judgment in any case. And that was what he said, that the judgment of January 14th did not meet the justice of the case. But Supreme Court also, in the majority judgment of 6-1, dismissing the application, said it would cause chaos if their earlier judgment was reversed. Okay. Because there was tension already mounting in Imo State. Meki Ihedioha scam and Hokus Odimma scam. So Supreme Court looked at the stability of the state and the crisis that might follow the judgment if it was reached on merit.
Are you saying that the Supreme Court gave the judgment on sentiment?
On sentiment. The Supreme Court gave the judgment to ward off the consequences of politicians abusing the court processes. Like, if you looked at the issue, the first case was the case of Bayelsa. Supreme Court imposed fine on the litigants because there was no grounds for appeal. Supreme Court of Nigeria had, in a case, I cannot remember the particular litigants in that matter, spelled out 5 grounds upon which they can sit over their earlier decision and indeed set it aside. And one of the instances is where such judgment was reached in error. And just if you took time to look at the judgment of Justice Cletus Nweze, you will see that he was talking about the number of accredited voters being less than
in the 388 polling
being less than the number of votes in that 388 polling units, which is an error. And the law is right. The law is right that number of accredited voters must not be more than number of voters. You understand? And these.
But if you ask me, the Supreme Court in the case of Benue and in the case of Kano State have adjudged that they are not INEC to begin to look into electoral processes or whatever, that the fact before them is what they consider.
But the fact before them must be reasonable enough to be admitted in evidence. You cannot just manufacture evidence and mislead the court into giving you judgment. That was what Justice Nweze said. They were misled.
But INEC accepted the...
INEC did not.
INEC accepted that verdict from the first instance. INEC accepted that Uzodimma was right.
If you read the judgments yesterday, the court said, what INEC said was that there was no compliance to the 2010 Electoral Act as amended in those 388 polling units. It was in the judgment of Justice Nweze.
Okay.
So if the law that is supposed to govern the electoral process was not adhered to, how can you validate the results from those polling units?
All right, I'll come back to you again. And Aisha, I would love to ask you this simple question. Do you think that judgment was based on sentiment? And what implication the dissenting view of Justice Nweze could portray? in
I'm
the
going
future?
to second what Sylvanus said, everything he said. But the only angle I'm going to come from is the fact that, okay, I know both cases, both review, the cases, that of Bayelsa State and that of Imo State, they are not the same. But then again, if the Supreme Court had asked the All Progressive Congress in Bayelsa State to go ahead and pay money.
A fine,
right? So I'm just saying, how come the PDP, the People's Democratic Party in Imo State, were not asked to pay?
Yes, I was wondering too.
I want Sylvanus to say something about that. That was the only angle I was going to come from. He kept on saying the Supreme Court is this, is that. So this is press talk. So I need you to talk about that. You didn't actually really.
Was it okay? You finished.
That's the only angle I'm coming from.
Okay.
I do not have
Mr. Sylvanus.
against
today I'm not the analyst here. That is another angle, because the first judgment of a Bayelsa that was against Leon that was thrown away, they charged them with fines running to about 30 to 60 million that the lawyers should pay, lawyers to the APC and that of Leon should pay. In the case of Ihedioha, we thought that fine could serve as deterrent to Ihedioha, to Kano, to Zamfara, so that they will not approach the Supreme Court.
So that they don't get to abuse the court process.
Yes, we saw that the judgment from Tanko, the panel led by Tanko, was like no fine was given against PDP and Ihedioha.
After the two cases have been dismissed.
Yes, they have been dismissed.
They are
so
both
that and fine should be allocated. Do you
fines
see a kind of
let me start by correcting this.
partiality
It's not just
here.
a fine, it's a punitive fine.
Okay.
And this kind of fines arise only when there is no merit in an application. You bring a case up just to waste the time of the court. If we have a functional bar, Nigerian NPA, Nigerian Bar Association, those people should have been questioned, because for the court to find them, it means they are engaged in an improper conduct. You understand?
Okay.
Why they were fined was because the case, there was no substance in the case they filed before the Supreme Court. So when the Supreme Court went through it, they saw that their time, they wasted their time. The case ought not to have been filed in the first place, because they don't have grounds of appeal. You understand?
I don't want to go into that, because if you go into detail,
but then
I would on my own say that the Supreme Court
came out to say he had every right to go ahead with the case.
You know, that of Bayelsa State is even more promising.
Let me tell you what every lawyer is
taught
in the Nigerian universities and the law school. Okay. The first thing you do to a client is to give him legal advice. If he brings a case to you, you tell him if this case can fly or not. You owe it to your client.
And who said the case of Bayelsa could not fly?
That is what the Supreme Court is saying. That it was a blank case, a blank.
How is it blank? Let me ask you this question.
There was no substance in it.
Do you think that the Supreme Court could be biased at any time?
The justices of the Supreme Court are humans.
Good.
And they are not perfect.
They are not infallible.
All right. But then they are not biased. They don't belong to political parties. They don't participate in elections. They give meaning to the law brought before them for interpretation.
I do not agree with you. You say they are not biased. You have Mary Odili in the case of the Bayelsa State, so you're saying they do not belong to any political party.
Okay. This is it. I do not agree with you.
Thank you, Aisha.
If APC,
I think Aisha is right. I didn't mean it was Mary. Tanko. Imagine Tanko had disappeared yesterday and left this judgment for justice like Mary Odili or any other affiliated justice.
They have independent cast of minds, just like Justice Nweze.
But could they err?
Yes.
But you just said they are not biased.
They are not biased. Okay. It is conviction. They have read. They are learned people. It is not how you interpret the law that I will interpret the law.
Okay. Okay.
That is why they don't reach they didn't reach a unanimous judgment yesterday.
Yesterday was 6 against 1.
Yes, because of the way each one of these justices interpreted the application before them. But if you recall, in the case of Bayelsa, it was a unanimous judgment. All of them on the panel, 7 persons, did not see merit in the application filed by Wole Olanipekun and Afe Babalola. Are you saying that they are all PDP members?
Okay, we're talking about the fine now.
That is it.
So, the two cases.
Why they were fined in the Bayelsa case is because Supreme Court said they ought not to have filed the case in the first place. I've always given
to review the
they
case.
Shouldn't have, because there was no grounds. There
are
5 grounds upon which you can fight for review before the Supreme Court.
Okay.
Now, Supreme Court said their application did not fall into any of these instances, which means it was a frivolous case brought before them to waste the precious time of the court, and then they must pay for wasting the time of the court. But yesterday, if you watched the angle,
could you give us 1 or 2 of the grounds?
One, if the earlier decision was reached per inquiry, if the evidence upon which they based their judgment was faulty,
okay,
or if they were misled by evidence that does not, because Supreme Court, they are just in the court, they did not follow you to where election was conducted. If they discover that the evidence you brought before them does not exist, or that you manufactured evidence, they can, and if they see that the judgment will cause manifest injustice in the future, they can differ with it from the earlier decision. But yesterday, the ground upon which Kanu Agabi based his argument was that the number of accredited voters was less than number of the votes, and the Electoral Act condemned this ground, that there is no way you can win election when people accredited for the election are less than the number of voters.
All right.
And secondly, that the Supreme Court did not take further steps to ascertain if Uzodinma met the requirements of the Constitution, this parade, which are these are the things a governorship aspirant or a candidate must fulfill.
Unlike in Bayelsa, Aisha, that in Bayelsa State, that Mary Odili threw out against David Leon.
Mary Odili is a one person.
Diri,
just one.
I know. Diri, the now governor of Bayelsa State, Diri never won 2/3 majority and 25% across the 8 local government. Right. He only won 2 local government and shortfall of the required vote. But the Supreme Court gave their verdict and said that the vote of APC were completely nullified,
which makes him highest winner in all the
which now enthroned him and his vote. Don't you see biasness in this conflicting judgment and the dissenting view apart from other justices who are involved? The populace.
I said it earlier that the fact that Sylvanus here is an authority in the law, and he keeps saying there is no bias, the judges that
no, he said they could be biased. He said so.
He said they could be biased.
He said they could be
the fact
biased,
that he's saying all of that,
human.
I feel when you even critically look at these cases, both the case of Bayelsa State and the IMO State, as much as we say Supreme Court is the apex court, they are infallible and all of that, I don't know the legal terminology you use, I still feel if we want to look at these cases critically, you'd know that some of the judgment they pass, some of the verdicts,
conflicting.
They are very conflicting. They are indeed conflicting. Because if you're saying David Leon qualified everything and he had 25% vote across
all the 8 local governments and was cancelled completely on the ground that
the ground that this person he tagged along with provided a fake forged certificate. And so is that does that mean the vote for David Leon, the fact that he was earlier pronounced as the governor-elect, so everything has to just go ahead and die down like that. And now we're still talking about the Hope Uzodinma and also Emeka Ihejo.
And again,
now you're saying there are no grounds for filing the case in the first place when all of these evidences have been provided. And now, but the case of Imo State, there are grounds for providing.
You can imagine. And apart from that, the Supreme Court based their judgment of Bayelsa State on forged certificate. They have jettisoned completely the electoral process. They have jettisoned INEC, the ballot boxes, all the suffering, the staff, whatever.
And then he didn't mention any. He didn't talk about the fact that all of the judges that presided over that.
So what is the essence of the electoral reform? Okay, what is the essence of the electoral reform? If the Supreme Court could jettison vote casted on the ground of forged certificates. React, please.
Section 187, subsection 2.
And section 3882, subsection 9.
is clear
Okay.
that for a party to have a valid candidate in an election, there must be a deputy. The absence of a deputy vitiates the candidacy of a political party in a governorship or presidential election.
But that is a pre-election matter.
Yes.
Should Supreme Court dwell on pre-election matter?
That has not finished.
It has finished.
It hasn't.
He has already won and declared winner.
The case finishes only if Supreme Court decides on it. And do not forget that before the election, there was a High Court judgment declaring that APC had no candidate.
An appeal court judgment to substantiate that he remained the deputy governor candidate.
And Supreme Court now came and said he didn't qualify.
And Supreme Court, according to Falana, said they were not supposed to dwell on matters of pre-election.
Is Court of Appeal the highest court of adjudication in pre-election matters?
Of course.
No.
Not Supreme Court.
No. Supreme Court is the highest court of appeal, except
on pre-election matter.
On pre-election
not post-election matter.
Pre-election matters, except
the
all pre-election matters. Supreme Court is the highest.
We will take a short break from here, and when we come back, we'll look into another trending issue. The Speaker of the House of Representatives of the Federal Republic of Nigeria at the National Assembly, Femi Gbajabiamila, was allegedly said that he sponsored 300 persons to celebrate his mother's birthday in faraway Dubai. Stay tuned. After this time out, we'll be with you. Before we went on break, this is Press Talk on TVN, and I said that Gbajabiamila Femi, the Speaker of the House of Representatives of the Federal Republic of Nigeria at the National Assembly, was allegedly said to have sponsored 300 persons to faraway faraway Dubai for the celebration of his mother's birthday. Now, some persons were of the opinion that it is not public funds that he used. Others said that even if it is not public fund, that is lavishness. So let me begin from you. The point of transporting persons up to 300, as alleged, to Dubai to celebrate birthday. Is it picnic? Is it tourist attractive area, the reasons? Or
I think I'm going to react to that in this regard. I think for the fact that he's a public official, right, and for the position he holds, that act, people would term it as is inappropriate for him to sponsor about. Allegedly, he had sponsored 300 persons to Dubai to celebrate his mother's birthday. But then again, I think we have to carry out investigation to know, is it his personal fund that he used, or is it the public fund? But I'm just going to come from this angle that for the fact that he is the Speaker of the House of Representatives, and then all eyes are on him, he's the number 4 person in the country today. So whatever he's doing, that people would term that as lavishness. He was just being lavish. Right, because if you have to celebrate your mother's birthday, the country is here, Nigeria is here. We have a lot of places you could have taken your mother and the guests, the 300 persons allegedly that you sponsored. There are places you could have, the birthday could have been celebrated here. You're not a celebrity. If you were an entertainer,
he's not a celebrity.
Right. If you were an entertainer, maybe somehow you'd feel the need to, let me take people to Dubai for a lavish birthday weekend or something. But then you're not a celebrity, you're a public officer, you're number 4 person in the country, and then the world is watching, Nigerians are watching, and now look at this is coming out after the birthday the birthday celebration had been done. And if it didn't come out, we wouldn't have known, although it is alleged. That's why I said we need to carry out investigation to know if this actually happened, and then if it did happen, which money did he use?
Some quarters had it at 90, and from what I read about him this morning, he said that he never used public fund. But let me come to you, Silvanus. That act, was it exemplified enough for others to follow as a precedent?
I think before I comment on that, I want to say that the action is condemnable, is outrageous, unbecoming, indecorous of somebody who holds an exalted position such as the Speaker of the Federal House of Representatives as a public officer. Your life remains in the realm of the public. There are certain actions you don't take because of the high standard that is expected of the occupant of your office. The Speaker of the Federal House of Representatives' argument that he did not use public fund is lame. I am saddened that he is coming from a speaker who presents himself as a legal practitioner.
And a one-time man of God, pastor.
There is no way you can justify these actions if the money is not public fund.
But don't forget that we were taught to celebrate life instead of death.
You can celebrate it in the country. We have
that was the point I was raising earlier.
We have
we should promote
this one in Bauchi.
Yes.
What is the name?
Yankari.
These are times that the lawmakers, are telling us to patronize Nigerian made products. They have closed the borders. We cannot access foreign rice because they want us to domesticate, to make use of.
In fact, the Nigerian rice is so sweet. I don't regret that at all.
Likewise, Nigerian cars and our hotels, they are good too. Because these people, they have told us to continue to patronize Nigerian rice and all these things. But the House of Representatives, under his leadership, recently rejected the offer to use innocent Nigerian-made motors.
I was going to come to that.
And this is wrong. That the same speaker, when the dust raised by that first allegation had not settled, he is flying hundreds of Nigerians to Dubai to celebrate the birthday of the mother. It is a good thing to celebrate your mom, but it's also a good thing to hold dear to the tenets of your office. If you're a public office, people expect a lot from you. He is a leader of a constituency, a constituency made up of people. And these people are looking up to him. Most of these people cannot afford 2 square meals a day.
Exactly.
it is insensitive
well,
for him to
I will
embark on
cut
such.
you off there because our time has been fast spent. Maybe one word from you in 1 minute. Then
Okay,
we'll wrap it up.
for that particular act by the Speaker of the House of Representatives, it's indeed insensitive and it was totally uncalled for.
Okay. Well, very, very insensitive and uncalled for, unprecedented act, and should not be condoned. It is not an exemplified act from Mr. Speaker. Mr. Speaker, I believe you are listening to us. Your people are saying that was an extravagant act and you need to turn over a new leaf. This is where spectacle, press talk will stop today on Television Nigerian, and please continue to follow us on our social media platforms and drop your comments in any of our interested topics or subjects. Thanks for watching.